Hello, everyone, and welcome to Uncivil Law, where we learn through others' misfortunes. To help increase your legal knowledge, please hit the subscribe button. For today's case, we're dealing with some retaliation by the FBI against some Muslims in the United States. This is the case of Tanzin versus Tanvir. In this case, the FBI approached various Muslims in the United States, and they wanted them to be informants. And these various Muslims refused. They didn't want to be informants. So the FBI put them on the no-fly list. And of course, they found out. And then they petitioned to get off the no-fly list, and they were eventually dropped from the no-fly list. But now they'd like to get damages. In fact, they'd like to get damages from the officers personally for this retaliatory behavior. So the question is, can they get at the officers? Can they sue for damages? What are the standards relevant here? And why is this lawsuit perhaps just a little bit different than your typical qualified immunity case? Let's get started with this. We have to determine if injured parties can sue government officials in their personal capacities. The Religious Freedom Restoration Act text provides a clear answer. They can. Persons may sue and obtain relief against a government. The law, which is defined to include a branch, department, agency, instrumentality, and official, or other person acting under color of law of the United States. So the first reason that things are a little bit different here is we're not just suing for constitutional violations. Right, we're not just suing for First Amendment. We're not just suing for Fourth Amendment. So we're not doing the standard qualified immunity analysis in this one. And we're not doing the standard qualified immunity analysis for a very particular reason. There's a statute that Congress passed called the Religious Freedom Restoration Act. It was passed basically unanimously. I think it might have been unanimous. I'd have to double check. But I think it might have been unanimous when it was passed. But basically says to the federal government, at least as a matter of federal law, that you can't discriminate on the basis of religion without strict scrutiny. It overturned a bunch of cases by statute that went the other way in some contexts. So it elevated religious discrimination in many ways. And so their argument is we were discriminated against religiously. So we're not under a standard First Amendment analysis because we have something more. You know, we can always go further than the First Amendment allows for. So if we were doing a standard First Amendment analysis, we'd have to be talking about qualified immunity, it was clearly established, all that great stuff. But fortunately, statutes can go further than the Constitution. And Congress did go further. They wrote the Religious Freedom Restoration Act, gives you specific rights, including the right to sue officials, including them in their personal capacity, for money. How fun. The government urges us to limit lawsuits against officials to suits against them in their official and not personal capacities. A lawsuit seeking damages from employees in their individual capacity, the government argues, is not really against the government because relief can be executed only against the official's personal assets. Yeah, if you sue someone personally, and you win, you can only get their personal assets, not government assets. The problem with this otherwise plausible argument is that Congress supplanted the ordinary meaning of government with a different express definition. When a statute includes an explicit definition, we must follow the definition even if it varies from the term ordinary meaning. So when Congress defined what government means, they defined it in a particular way. So we would agree with you, but the Congress wrote a specific definition and we have to apply that. And under this specific definition, that's not what it says. So what is the government? Well, when it comes to the Religious Freedom Restoration Act, a government extends beyond the term plain meaning to include the officials. And the term official does not refer solely to the office, but rather to anyone invested in the office. So government has been expanded by definition. Not only does the term government encompass officials, it authorizes suits against other persons acting under color of law. The right to obtain relief against a person cannot be squarely put together with the government's reading that relief must also run or always run to the U.S. government. So you can get to the U.S. government, and you can also get to the people behind them. The legal backdrop against which Congress enacted the Religious Freedom Restoration Act confirms the propriety of the individual capacity suits. The phrase persons acting under color of law draws on one of the most well-known statutes, 42 U.S.C. 1983. So we're not doing a 42 U.S.C. 1983 case today. That's why we're not talking about qualified immunity, because we have a whole different statute. So we don't have to do the 1983 qualified immunity dance, because we can go talk about RFRA instead. That statute applied to persons under color of statute, and this court has long interpreted to permit suits against officials in their individual capacities. Yes, it does, but normally they get qualified immunity, as we've discussed many times. But the Religious Freedom Restoration Act, that's a whole different ball of wax. Damages are also commonly available against state and local government officials. In 1871, for example, Congress passed the precursor to 1883, imposing liability on any person who, under color of law, deprived another of constitutional right. By the time Congress enacted the Religious Freedom Restoration Act, this court had interpreted the modern versions of 1983 to permit monetary relief against officials who violated clearly established law. That's the qualified immunity language when we talk about 1983. But we're not talking about qualified immunity. We're talking about Religious Freedom Restoration Act, because the reason that they discriminated against is specifically because of religion. And Religious Freedom Restoration Act applies to federal officials, including the FBI, including the TSA. How fun. A damages remedy is not just appropriate relief as viewed through the lens of suits against government employees. It is also the only form of relief that can remedy some violations. For some injuries, such as respondents' wasted plane tickets, effective release consists only of monetary damages, not just merely an injunction. So you can get money for this, and sometimes it's the only form of relief that you can get. So you can get money. The government also posits that we should be wary of damages against government officials because these awards could raise separation of powers concerns. But this exact remedy has coexisted with our system since the dawn of our republic. To be sure, there are policy reasons why Congress may wish to shield government employees from liability, and Congress can do so if they want to, but there are no reasons why we must do it in their stead. So if Congress wants to shield them, they can. If they don't have to, and it's not for us to do it in the first instance. It's up to Congress to do policy. We conclude that the Religious Freedom Restoration Act's express remedies provision permits litigants, when appropriate, to obtain money damages against federal officials in their individual capacities. The judgment for the Second Circuit is therefore affirmed. There was a law, they violated it, they're personally responsible for their actions, so you can sue and you can get at the agents personally. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.